Miss Liebeck ordered a 49-cent cup of coffee from a drive-thru. While stopped, the coffee spilled in her lap, causing severe third-degree burns on her thighs and groin. She spent 8 days hospitalized and required skin grafts. Liebeck first offered to settle for $20,000 to cover medical bills, but when McDonald's refused, she sued for negligence. The case became a national sensation and is often cited, wrongly, as an example of a frivolous lawsuit. In reality, the facts were harsh. McDonald's had received more than 700 reports of burns from its coffee over the prior decade and knew its coffee was unusually hot. The jury found McDonald's 80% at fault, seeing it as a dangerous product at that temperature. The case sparked a tort reform debate and remains one of the most famous personal injury suits in US history. Outcome: the jury awarded Liebeck $160,000 in compensatory damages for medical costs and $2.7 million in punitive damages. The judge later reduced the punitive award to 3 times the compensatory, $640,000 total. McDonald's appealed, and the parties ultimately settled out of court for an undisclosed amount. Reports suggest a few $100,000. The case forced McDonald's to change its coffee-serving practices. Sid and Marty Krofft, children's television producers, creators of HR Pufnstuf vs. McDonald's Corp. And its ad agency. The Krofts sued, claiming McDonald's children's advertising characters, notably Mayor McCheese and others from McDonaldland, copied elements from their show HR Pufnstuf, whose main character had an enormous head and was also a mayor. They alleged McDonaldland ads took the total concept and feel of Pufnstuf. This is a rare and whimsical copyright case. A kid's television fantasy sued a burger ad campaign. The idea of suing over cartoon characters made national headlines. It's a David versus Goliath story in entertainment law, showing even a giant like McDonald's can infringe a small creator's work. Outcome: the court ruled in favor of the Krofts. In 1977, McDonald's was ordered to pay $1 million in damages and stop airing the infringing commercials. McDonald's subsequently altered its character designs. The case is remembered as a landmark example of protecting creative rights, even against a mega brand. Supermax Limited, an Irish fast food chain, versus McDonald's Corp. EU Trademark Office. Supermax sought to register its own name in the EU and challenged McDonald's Big Mac trademark. McDonald's had opposed Supermax expansion, arguing Mac names would confuse consumers. The EU proceedings evolved into Supermax attacking McDonald's trademark rights. Supermax argued McDonald's had not genuinely used Big Mac for restaurants in Europe and accused McDonald's of trademark bullying. Outcome: in June 2024, the European Court of Justice ruled for Supermax. It ordered Big Mac delisted as a trademark for restaurants and barred McDonald's from using Big Mac on chicken products. The ECJ found McDonald's had not shown active use of Big Mac on those goods, uses in the EU. Effectively, McDonald's cannot prevent Supermax from using its own name. Supermax hailed it as a victory against corporate bullying. McDonald's may still use Big Mac on beef burgers in EU, but the famous name is no longer fully protected as before.